right, court does call the case of the people versus Isaiah Williams. Yes.
Good morning, Your Honor. Danielle Russo-Bennett, Department of Attorney General, on behalf of the people.
Pretty Judge Torshell Feaster, Assistant Public Defender, on behalf of Mr. Isaiah Williams. Mr. Williams, please state your name for the record.
Isaiah Williams, pro purpose Sonic. I've explained to the court, Your Honor, that I told Mr. Brown, and as I have stated,
Mr. Williams, Mr. Williams, I'll tell Judge what's going on. Just give me 1 second, okay?
Well, I'm trying to explain it because you haven't been able to do so, Your Honor. That's why I'm saying it, because this officer, this attorney here before you, something is wrong here because we have a lack of communication. I keep taking writing to their people and writing and telling them, you understand, and I read it. Hey, look.
I'm going to tell the judge that you want to go.
Who is the Chief Public Defender's Office in Washington County on April the 22nd. Then I've written her again, you understand, another copy just last week. And I took it straight to them on the phone, Your Honor. And every time I talk to these people, they do not get to comprehend that I no longer wish they help at all. They are incompetent. They are not providing me with what I need. I need someone who can represent me, that's going to take and let me know what they're doing in my best interest. These people are not working in my best interest. They do not want me to take and get a copy of a true motion for discovery. They do not, you understand, want to get me in the courtroom where I can take and bring the deal that I want this illegal device taken off my person, that I can be able to sit in the courtroom and be free of the privacy of my mind. I have a device on me, Your Honor, and it invades my privacy of mind. The United States Supreme Court Justice said they would not allow such an atrocity on the United States citizen to walk around with an invasion of privacy of mind. But yet, these people here who want to represent me go tell me today, we can't even get your property. I've already, you understand, been illegally kidnapped on October the 12th in Chicago off a CTA bus, Your Honor, and was kidnapped and robbed.
No, you were not kidnapped. You were arrested. We've already been through that before.
I was not arrested, Your Honor. I was kidnapped and robbed for
yeah,
$12,000.
You were arrested.
My property. Now the property doesn't come up.
Kidnapped, arrested, tomato, tomato. All right.
You don't want to hear it, I know it.
No, I'm listening to everything you're saying. At least those parts that make sense. Mr. Feaster, you were saying.
Thank you, Judge. I've spoken to the Attorney General's office and to Mr. Williams. Mr. Williams did indicate to me that he wanted the letters that he sent to our office returned to him so that he could file a motion on his own behalf. For our part, Your Honor, our office has hired an independent investigator to look into this matter. I am waiting for a report from that investigator. If we could have about 4 weeks, Judge, to get that report, then I'll make sure in the meanwhile, I return to Mr. Williams all of the communications he's sent to our office. So he has everything that he needs, and he already has his discovery, Your Honor, just for the record.
Before I hear from the Attorney General, just so
Your Honor, I do not want to take it.
Mr. Williams.
I'd appreciate it, Your Honor.
Just
I have
stop.
almost 5 different.
Just stop. Mr. Williams.
Yes,
stop.
Your Honor.
I've listened to you. Now you're going to listen to me.
I will.
So that counsel's aware, Mr. Williams did file some documents. Some of them I don't entirely understand. I have reviewed them. One of them is a form motion for discovery. I don't know that what he has put in there is applicable to this case. However, upon receiving that, what I did is I sent copies of that to the Attorney General's office, or had the clerk send it to the Attorney General as well as to the Public Defender's office, because it appeared to me that counsel may not have been aware that this had come in. All right, Madam Attorney General, is there anything you'd like to say?
There is a couple of points. Thank you, Judge. And I do appreciate the court sending that to me. And I think that we're going to have to make a record on this, whether or not Mr. Williams is really competent, in fact, to represent himself. You did make it clear to him at the last hearing that If he does choose to go forward on his own behalf, he has to serve the people. He did not serve us with any of those motions. So I do appreciate the court sending that to us. I think the court statute and the case law is very clear that he has a right to. However, it must be knowingly and intelligently done, and that the court is going to have to make him aware of the pitfalls, the dangers, the disadvantages of what that really entails. He does not have an absolute right as well to question the victims in this case. And so I think that's the Daniels case. I bring that up for a very specific reason, and maybe Mr. Williams needs to hear this as well. Mr. Feaster is aware that I did file a very substantial, extensive other acts notice with the court way back in January, and served it upon Mr. Feaster. It is extensive in that the people have put the parties on notice that I intend to produce an extensive amount of domestic violence and sexual assault evidence at the exam if Mr. Williams intends to, in fact, hold his exam. So he needs to be aware of that and be prepared to knowingly be able to address that at the exam. And so that is one of the issues that I wanted to address as well. One of the other things that I wanted to ask, I know Mr. Feaster said that Mr. Williams is going to want some additional time to perhaps go to the law library, to do some research and file some additional motions before deciding whether to set an exam. I have absolutely no objection to that, because if this does go to exam, I expect it will be lengthy, 10 witnesses or so, and we have some out-of-state witnesses, so I have no objection to that. One thing I am going to ask of the court to consider, and obviously the court doesn't have to consider that today. If this does go to exam, I would ask you, Judge Simpson, to consider retaining this case for exam. I know that you're very busy and your docket is very busy, but because you are aware and you've had this case since January, you are aware of the unique challenges and issues in this case, you are ultimately probably going to have to make a ruling on whether or not Mr. Williams is going to, in fact, be able to represent himself going forward, at least at this stage. And because of the length of the exam, I'm going to ask that you at least consider retaining this case for purposes of preliminary exam.
Since you brought that up, I will just, it's a very quick answer to that. I realized based upon what had previously been filed, where this case started, that it was probably going to be in the best interest of judicial economy and otherwise that I do retain the case. And so that is my intention.
Thank you, Judge.
For Your Honor, if I may address to the court, if you please. For Your Honor, first I'd like to take and state to the court that I have went through and looked at some constitutional statutes here. I said on October 12th, I constituted as a kidnap. You said it was an arrest. I was not given no memorandum of right. I was taken off the bus. My property was taken, and I was informed by Mr. Pretrial that they were telling me they can't find my property. So evidently, I constituted as a robbery. Over $30,000 have been taken from me. I have 3 children, minors, and they have been taken away from me after their mother has deceased on July the 21st of last year. That's how I got this money. This money was the $20,000 came from the insurance policy, and the $12,000 came from Mariana grocery store for where I was injured, where I was jumped on. This is how we found out.
Okay.
May I address 2 points, Your Honor? I know you're very busy. Mr. Williams.
Mr. Williams.
Thank you. I appreciate it. You said this is my hearing. I'd like to take a speak.
No,
Mr.
Williams, no. Mr. Williams, this is my hearing.
Fifth Amendment right, and the 6th Amendment right, the 8th Amendment right, the 9th Amendment right, and the 14th Amendment right.
One more word and you're muted.
I've been denied all of these rights.
Madam Attorney General.
Thank you, Your Honor. I did not get a chance to address the discovery just because it's an official, I don't know if it's official, Your Honor, but it's a filed motion for Mr. Williams. Mr. Feaster was delivered a voluminous amount of discovery in January, and obviously he is the one who has the right under the court statute to the discovery and to share it with his client if he chooses. He said he's done so. And just with Mr. Williams, this is the second time he's brought up his minor children and getting out for his children. I just want the court to be put on notice. Mr. Williams was residing, and by his own statements to law enforcement for 20 years in Chicago, Illinois, and he was not, the children that he is speaking of were not in his care and custody. They are here in the state of Michigan. He was not taking care of any of those children. So I just want the court to be aware of that.
All right, very good. Mr. Feaster, Go ahead.
Yeah,
What were you gonna say?
I don't know if another competency referral may be appropriate in this case, Your Honor. I'm having difficulty communicating with Mr. Williams. My thought is that I can have our social worker at our office go and meet with him and speak to him, and she can maybe give me some guidance and advice on next best steps for dealing with Mr. Williams and trying to move this case forward, Judge.
And Your Honor, he absolutely has a right to an independent, and I obviously would not be able to voice any objection to that. And I think that I don't even have a concern with that at this point. I think the report was short. The last report we had was kind of basic. It was kind of short. It didn't have a lot to it. I would agree on that point. But Mr. Williams has brought up 2 points that I know we can't ignore over the last 2 hearings. And I know Mr. Brown was present at the last hearing. He keeps referring to a chip that is inside of him. Mr. Feaster and I are in receipt of many, many medical records for Mr. Williams that do not cite to anything that he is talking about. So that is concerning to the people that he keeps very zealously referring to this chip that is inside of him. He's asked you twice to court order it be removed. I don't know what he's referring to. That's concerning to the people.
Yes, there's a number of, quite frankly, what's being said by the defendant that is concerning to the court, and particularly the relief that he's requesting of the court. Mr. Feaster, in terms of an independent, are you going to be making that request or?
So yes, Your Honor. So my initial thought was to have our social worker speak to him, since she has more versed with mental health than I am, and to get her take on that, Your Honor. But I do think an independent is going to be necessary given the statements that Mr. Williams is making and his request to represent himself. And I just want to make perfectly sure that he is competent to move forward before we put him in a position to put himself in line for a potentially very long prison term, Your Honor. So I would like to make sure he is able to proceed and aid in his own defense, Your Honor. So I would like to move in that direction, Judge. Yes.
All right. Well, let's do it this way. I'm not going to even, and I realize why people have brought this up, I'm not going to even address any medical issues, whether it be a chip or anything else, until such time as this defendant, we get through the issue regarding competency. It becomes difficult, I think, also given what the defendant has said, for the court to even properly address the defendant's desire to represent himself, because I'm not clear that without additional information, the court's not clear that that decision on his part is even voluntary. I couldn't in good faith say that, given what he's saying to the court and what he's expressing to the court. So I guess, Mr. Feaster, how long would it take you for your social worker to make the attempt and maybe be successful in speaking with Mr. Williams? How long will that?
I can put in an emergent request, and I think she could go see him within a week, Judge, and evaluate him. And then if she determines an independent is appropriate, I can seek approval from our management to get that started, Judge.
All right. And I don't know how long that process would take. So I am inclined to just adjourn the probable cause conference with that. There is also, and at this point, you are counsel record, there are also these motions that, this motion that has been filed. Here's how I'm going to lead the motions at this point. If, as counsel of record, you deem it appropriate that they be filed, or be heard, then somehow or another, either that you'll sign on to these or place these in some form that the court can understand them and that the prosecution would be able to answer if necessary.
Yes, Judge.
To the extent they need to be. So you had originally requested a month adjournment. Are you still requesting that time period, or did you were you looking at something else?
I would still request at least a month, Judge, because I think we have a lot we have to tackle here in this matter. And so I request at least a month, please.
Mr. Feaster, the master of understatement. All right. Without objection, I will adjourn this as the probable cause conference. I'll adjourn this out to July 21st, 2022, 9 a.m.
Thank you so much, Judge.
Thank you,
The
Judge.
bond will continue as denied. Mr. Williams, I'm going to give you one admonishment. When you come back on the 21st, if you're going to represent yourself at some point, regardless of what it is, you will conduct yourself properly before this court. You will not try to overtalk me, because that will not happen. All right? Am I understood? You can nod if you understand me, because I'm not unmuting you. Okay, there is no nod. I've said what I've said. I will expect your behavior, and that you will govern yourself accordingly. Thank you, folks.
Thank you, Judge. Thank you,
Judge.
Attorney General.
Thank you, Mr. Feaster. Judge, my good friend Yasmin Tucker wishes me to convey, she says hello to you.
Tell her hello and let her know that we've forgotten her name.
Don't even know.
Don't even know her.
She's dead to you.
Thank
Have
you.
a great day. Thank you, Judge.
Thank you.